morning. Why does it seem like not all 133 of us are here? Maybe I can't count. Did everyone have a nice weekend? Yeah? Okay, a few administrative matters. No class tomorrow. I'm sorry to do this to you again. I had an unexpected invitation to present up in Boston, so I am going to be out of town tomorrow. That means there are no office hours this week, but not many of you came last week, so maybe more of you will come next week. So next week we'll just return to our regularly scheduled programming of Tuesday, Wednesday, Thursday class and Wednesday office hours. If you want to email me beforehand, great. If there's a particular time that works for you, great. Otherwise, I'll just be around after lunch. So starting 1:15, 1:30ish, just feel free to come all the way to 4 or so. Okay, so let's just take a step back and try and situate the material that you've read. Let's just figure out where we are. Okay, so the section of the casebook that contains Burlington. Remember, we didn't get to Burlington last week, but we did finish Time Warner. Burlington and Time Warner both appear in a section of the casebook titled Rule 10b-5, Fraud in Connection with the Purchase or Sale of a Security. Now, as you can see from the syllabus, the presentation of the material, the order in which we're going through, the material doesn't really map to the order in the casebook, in part because the way that the class is structured for the first half, or up to spring break, is we're trying to understand what rules apply to issuers of securities. Remember, we said from the outset, securities law is about the regulation of communication between a firm and its investors. For the first half of the class, we're looking primarily at the 1933 Act in a formal sense, right? Remember, after we did a few weeks of economic theory, we then moved to Section 5. And Section 5 prohibits the offer or sale of a security under certain conditions, unless a registration statement has been filed. So a registration statement is filed pursuant to the 1933 Act. The 1933 Act governs the issuance of securities. Now, along the way, if you remember, we had to address questions like what should be included in that registration statement. And we saw that the registration statement, Form S1, contains instructions. And those instructions make a reference to one particular regulation among many, Regulation SK. And Regulation SK is very long. It has many items, many of which refer to this word material. So item 101, we saw, refers to materiality, and when giving the description of the business, we're seeing this word materiality material appear as a qualifier. We also see this word in other places. But in Reg SK, which is the formal logic that we're going through, which is referred to by Form S1, material shows up as a qualifier. And to understand materiality, we looked at Texas Gulf. And we talked about the probability and magnitude test, which is really the doctrine of materiality. And we sort of beat that horse, ad nauseum. We went sort of around. That was a bad analogy. We just went. I like horses. We just sort of went over this and churned it over and over again from many different angles, and we kind of talked about why we have a materiality standard. Here, as more people come in, it starts to feel more like 130. All right, here we go. So we talked about this materiality standard, which is very flexible, and we said, look, we want to think of it through a normative lens, right? We want to think, what are the goals that matter to securities law? And how can a particular construction of materiality further those goals? Now, that entire conversation really was a conversation prompted by affirmative disclosure rules, right? That is, you're filling out the S1. You turn to item 1.01, which refers you to item 101 of Reg SK, which has the word material in it, and you start to think, is a particular business plan that my company's pursuing, as you're filling out this registration statement, going to be encompassed by the materiality standard, going to be compelled? Is the SEC going to find that this is material? Or if this issue is litigated, will a court find it's material? Or even if I'm making policy, would this issue should it be considered material? Okay, so then we kind of switched gears and started talking about forward-looking statements. Now, forward-looking statements starts to take us out of the world of preparing a registration statement to some extent. Of course, when you're preparing the registration statement, you know, the issues around forward-looking statements that we read historically and touched briefly on last week arose out of debates over whether projections, earnings projections, should be included in forward-looking statements. But of course, projections are ongoing. There's a sort of an ongoing concern, right? Companies might describe their business once in a Form S1, but there's going to be new earnings projections disclosed on a regular basis. And so forward-looking statements starts to take us closer into the world of the 1934 Act, which governs ongoing disclosure by public companies. That is, companies who have issued a registration statement pursuant to the 1933 Act or are required to report and disclose under some other bases, particularly Section 12D, is it, or G, of the 1934 Act, which requires disclosure if you have more than 1,500, 2,000, I don't remember, shareholders of record, and there's an asset threshold. Is it, I don't know, 50 million? You can look it up. So the 1934 Act requires disclosure under those conditions. And we touched briefly on Form 8K, which is an ongoing disclosure obligation, just to complete the picture for our materiality conversation, because one item that has to be disclosed under Form 8K is a material definitive agreement. So we touched on ongoing disclosure, right? But we really didn't start from ongoing disclosure. We didn't start from the 1934 Act. We've only briefly mentioned it. But in fact, it turns out that most litigation in securities law is arising out of the 1934 Act. In particular, Section 10B, which we haven't really formally unpacked yet, is the basis for most securities litigation. Now, Section 10B prohibits fraud, and we're going to unpack the elements of 10B, and particularly we'll look at Rule 10b-5, which prohibits insider trading and other misleading statements or omissions. But we're going to do that in the second half of the course because that material really links to insider trading. It's really the basis for insider trading liability. But it turns out, in the confusing, convoluted mess that is securities law, that the doctrines that are relevant to liability under the 33 Act, which we're going to really unpack this week, happen to have, many of them have arisen in litigation under the 34 Act. Okay? So materiality was one example. Forward-looking statements is another example. So Time Warner and Burlington, notice, are not cases involving registration statements. They are not brought pursuant to Section 11, which you've learned about because you read Section 11 for this week. In fact, they were brought under 10b-5. They were questions of fraud. They were questions of misrepresentations or omissions. But it turns out that learning it through that lens, that is, the formal lens through which these cases were brought, that is, the formal causes of action that gave rise to these decisions, violations of Rule 10b-5, can leave you very confused. One reason it can leave you confused is because you're often starting, so far in this class, with an affirmative disclosure burden. So it's important to separate the questions. You'll start with a registration statement, and you'll start with a rule that's requiring you to disclose certain pieces of information, like information about the business, material aspects of the company's operations or whatever. You can look it up on item 101. And again, you'll have that for the exam. I'm just going to copy and paste it. If I don't know it by heart, certainly don't expect you to know it by heart. I mean, don't stress about that, right? Like, you're just going to apply. You're just going to go through the statutory text and just element by element, sentence by sentence, write what you would put in that registration statement as a securities lawyer. Like, literally, you'll start describing the company's business. But the question is going to arise, what do I do about projections of performance, right? It's very natural to say, look, this is a great operation. We have the best R&D. Look at all these patents that we've accumulated. We're sure that our sales for next year are going to be $10 million. You watch Shark Tank, like I instructed in the beginning, you notice that most of the sales pitch actually consists of projections, right? Like, they're standing up there, they're asked specifically often by the sharks, like, what are your sales going to be next year? $20 million. What's the basis for that? We've sold 5,000 so far, and that was 5,000 more than we sold the week before. If you watch the show, you would get that, because oftentimes these projections, which, by the way, the IPO VC valuations are just unbelievably high. When I first started watching Shark Tank, which was in 2009 or 10, there was a guy, for those of you who ever saw the show back then, let me draw a cat for you. Has anyone seen this business? So let me draw a cat for you. I think he got like 50 grand or something. It was like no money at all, and he gave up like a third of his business to get there. I don't know. It was like a really, really low valuation. It was kind of a crappy business too. But nowadays, you turn it on, and these people walk in and they're like, we're pre-revenue, pre-sales. We had a Kickstarter campaign where we raised we exceeded the expectations because we got $50,000 of idiots' money, and now how much is your company worth? $5 million, right? Do you have any IP? No, but our projected growth trajectory is, And you read about these IPO, well, not so much IPO, but VC valuations, and you think, like, what's wrong with the economy right now, right? Well, the problem is interest rates are really, really low. There's a search for yield. People are extremely risk-loving at the moment, hence why I would not have a lot of my money in equities, if you ask me, but don't this is not investment advice. But you do have to wonder some of these valuations. Why did I start talking about that? Well, if you go back to Shark Tank and you think about the basis for these insane valuations, it's really forward-looking statements, right? Forward-looking statements are forming the basis of the valuation. So it's very natural, as you are writing, filling out a registration statement, trying to solicit capital from investors, to say, these are our projected earnings, right? Now, having done that, at the moment of the registration statement, you are under no duty to do that. There isn't really a legal question about whether or not you can include a forward-looking statement in your prospectus. There is a question of the applicability of the safe harbor, and you should remember that in general there is such a safe harbor. So by and large, litigation over the forward-looking statement in the prospectus is going to be tricky. It's going to be tricky for the reasons we touched on briefly, as long as there is a reasonable basis or some sort of good faith in the preparation of the projection, which will generally be the case. It's going to be very hard to litigate the actual projection that's put in the prospectus. Okay, so where is this litigation arising? Well, it's not arising under the 33 Act. It's not arising under Section 11 or other bases for bringing a claim pursuant to the prospectus itself under the 33 Act. Rather, these are anti-fraud claims. Now, the elements of anti-fraud liability, it's like I'm just going to keep mentioning them. We're going to formally sort of break them down after spring break, because those are the elements of insider trading liability. But the first element of anti-fraud liability, of liability for securities fraud under Section 10b, is, in fact, some either statement that was made, some material, well, before we get to material, some misstatement, or a duty to disclose such that there was an omission in violation of that duty. So the first element in bringing a securities fraud claim is either you said something that was not true, it was a misstatement, or you didn't say something that you were under some duty to say. Now, as you read in Burlington, it's easy to conflate that element with the other elements, particularly materiality, okay? Because, like, I almost did it. I almost, like, said the word material without saying that that's element 2, right? So this is important. Element 1 is a statement or an omission in violation of an existing duty to disclose. Element 2 is materiality. It has to be the case that the statement or omission was material. But those are not the same thing, right? This should sound familiar from Burlington. Let's see where the court... Maybe this, hang on a second. Maybe this was time. 1 second. Here we go, yeah. Yeah, no, this is Burlington. So on page 1060 of the casebook, the Supreme Court is commenting on the Stransky decision. And the question that the court is asking is there a duty? Remember, I'm not going to go through all the facts of Burlington. There was an earnings projection. The company said, we're comfortable with that projection. The question was, as they gained more information later on that made the projection seem less realistic, were they required to tell the market about that new information? And what the Supreme Court points out on page 1061, if you look in the paragraph that begins, imagine the following situation, and you go down to the sentence that begins, in other words, so it's like, sort of midway through the paragraph, starting on the right side, a little bit below midway, there is an implicit representation in any forecast or statement of historical fact that errors, we'll talk about what errors they're thinking about here, of the type we have identified, will be corrected. This duty derives from the implicit factual representation that a public company makes whenever it makes a forecast, i.e. that the forecast was reasonable at the time made. So the question in Burlington is whether or not there exists this sort of duty to either update or correct. Now, it turns out whether you conclude that it's a duty to update or duty to correct is really almost conclusory. That's sort of the question. Because there's, in general, no duty to update, but there is a duty to correct, and thus the real question is whether or not there is a duty to say something more about your projection. And what the court is saying in Burlington is that there is a duty to correct. There is a duty to fix something you said if there is, in fact, an error in the information that gave rise to your projection, in a sort of ex ante error, right? An error that you discover it ex post, but you look back and you say, oh, if I had known that, in fact, I would have given a different projection to the market. So the duty here to correct is, in fact, a first predicate question. It's the element number 1 of the analysis. Because, why? Because this does not concern a statement. There's no claim in the Burlington case and in Time Warner that the information that the issuer had at the time it made the disclosure was the information the issuer had transformed the disclosure itself at that time to be misleading. So in other words, if you look back at when Burlington issued its earnings forecast, well, Burlington said it was comfortable with the analyst forecast. It's not that Burlington had some information at that point that undermined the forecast. It's that something arose later on, like they started to see the sales figures weren't as hot as they thought they were going to be. So if, in fact, let's just make sure this is very clear, at the time of the forecast, you know that the forecast is wrong, that's an easy case. That is not about failing to speak. That's about speaking in a way that's misleading. That's about lying. Okay? Very simple. Now, if you lie in a prospectus, that is, if you misstate a fact, like this is our projection, when it turns out that you know that projection is wrong, or you have that information, we're going to see in Section 11 that you're on the hook for that as an issuer. And it has nothing to do with the duty to update or correct or anything following that misstatement. That's the easy case. You thought your earnings were going to be $2 a share. It turns out you said your earnings were going to be $2 a share. It turns out you had some information that led you to calculate they were $1.50. You told the market $2. You knew you could only project $1.50. That is a misstatement. Is this clear? That's the easy case. What happens if you projected $2, but as time goes on, you start to realize, this is Burlington, that in fact that $2 projection was wrong, ex post wrong, like meaning I'm now realizing that earnings are only going to be $1.50 a share, $1.50 a share, not $2 a share. Well, what the Burlington court is drawing a legal distinction, this is the law, between whether or not the information you're getting concerns something you assumed or knew at the time of the projection. That is, if there's some sort of fact that you believe to be true that you then realize was an error. And so the court gives this example on 1061. A public company makes a forecast that it appears to it to be reasonable at the time made. This is higher up in that paragraph. Subsequently, the company discovers that it misread a vital piece of data that went into its forecast. Perhaps the facts sent by the factory manager in a remote location was blurry. Okay? So that's the example that the Supreme Court gives. And so management misreads 10,000 as 100,000 units and computes the forecast based on that. Now what the court is saying here is, look, in that case, there was some assumption, some ingredient that went into your projection. 100,000 units in this hypothetical. You realize later that that was an error, that the facts was blurry, and that the real number was 10,000. Are you under a duty to correct the earnings forecast that you gave the market? The answer is yes. No policy analysis needed. It's very simple, right? Maybe. But that's what the court says. And the duty to speak in that case arises from the implicit factual representation that the forecast, when made, was reasonable. Nod your heads if this is clear. Okay? Now, when analyzing, let's say, a failure to speak after the fact, like when the company realizes the facts was blurry, and let's say the company doesn't say anything, and you bring a lawsuit, what is the basis for liability that you're going to assert? What is the violation of law? What is the statute that you're going to cite as giving rise to your claim? It's going to be 10b. It's going to be 10b-5. Why? Because it's an omission. Okay? Because at the time, the statement was correct. So if you were to say that Burlington is a Section 11 case, I mean, it didn't involve an IPO, but suppose it did, and you were to, suppose the initial forecast came out in an IPO, and this was Burlington with an IPO and the twist that it was the facts, as the Supreme Court seems to suggest, the blurry facts. Would you be correct in asserting that that's a Section 11 violation? No. Not a Section 11 violation. No, nothing like Burlington could possibly be a Section 11 violation. Why? Because we have the assumption that the company's projection was reasonable, was based on the facts they had at the time. That takes us out of Section 11 land. It takes us out of any claim for affirmatively misleading the market. Now, the question then becomes, is the information that you discover later on concerning some sort of assumption that went into your projection at the time of the sort like 10,000 versus 100,000 units? And here, the court makes clear that if, in fact, it does concern some sort of fact like that, okay, like a blurry facts, an error errors of the type we have identified. So you start to be a little skeptical as to what that type is, but let's go with it for now. It turns out that that means what? That means that there's a duty to speak. Element 1 is satisfied. Do you still need to ask if the information that was not provided, the correction, was material? Nod your heads if you think so. Shake your heads if you don't. Nobody can see if you do it. Okay. So yes, you have to meet the materiality threshold for there to be liability for an omission. Okay, materiality is an element of any claim at least under 10b-5, and we haven't really unpacked that, so I don't blame you for not seeing that, but let's just make sure it's clear. The omission must also be subjected to a materiality test. Okay? So if this were litigation about the misstatement, it's possible that materiality would apply. If you look at section 11 on the screen, there has to be an untrue statement of a material fact or an omission to state a material fact required to be stated therein or necessary to make the statement therein not misleading. So at least section 11 is scoped to material facts, whether it regards a statement or an omission. But Burlington is not a case about section 11 liability. It is not a case about an omission under section 11. Just make sure this is crystal clear. Okay? So materiality attaches all the time. If we're talking about a section 11 case that is concerning a misstatement or omission in the prospectus, then it's subject to materiality. At least the fact has to be material. Now, the statement doesn't have material as a qualifier, so maybe you could argue under section 11 that not the update, but that if there were a section 11 omission, this is going to really confuse you. So you could have a section 11 omission, right? You have a section 11 misstatement or section 11 omission, which concerns information at the time of the prospectus. You could apply a materiality filter, which we'll look at more in a minute, to the facts that you misstated or to the omission in the context of section 11, but that all concerns information that you had at the time of the prospectus. Burlington and Time Warner involve cases that have nothing to do with information that you had at the time of the prospectus, but rather information that arose later on, and thus they're litigated under 10b-5. Under 10b-5, there's a materiality standard. All right, we're not looking at this text yet, so don't worry about it. But you're going to have to deal with materiality here as well. Now, I guess, some of you might really like this. You could imagine, what if the fact, was not material on the prospectus, but the omission has a material implication for the firm, or maybe more interesting is the fact in the prospectus was material, but the omission was not material. Okay, so I don't know, this could be fun to play with. Just take it one step at a time, right? Each moment in time each disclosure or lack thereof has to satisfy all the elements. And all that I'm looking for on an exam is that you're careful, okay? It's not a memorization exercise, but this is actually relevant to practice, unlike the theory. This is really relevant, right? This is what a partner will expect you to do, which is literally go element by element very carefully through the bases for liability at each point in time, all right? So this is training you to be lawyers, you have to have this skill. So you have to think very, very carefully. Okay, so Burlington, the question in Burlington is not materiality, but rather a duty to disclose. Everyone agrees that the sales projection here, the change in the projection is material to investors. This is the value of the firm, right? This is not is the mineral content going to misconfuse the market, where we start wondering, do we really want disclosure of those facts? No. We want disclosure of sales figures, okay, and sales projections. We want that, and like that's clear. That is to say, if there is a duty, this information is clearly material. Now, as the court makes very, very clear, there is not, and this is on page 1062, except for, in the middle of the page, specific periodic reporting requirements, there is no general duty on the part of a company to provide the public with all material information. So it would be wrong. Like, you won't get points for it. In fact, you might, like in a partner, will not be happy at a law firm. If you write, like, Burlington, was in violation of 10b-5 because the sales figures were material information and it had a duty to disclose that material information. Wrong. Wrong. Not going to get credit, okay? Make sure this is very clear. You cannot say that the updated sales projections or the information that gave rise to the updated sales projections must have been disclosed because it was material and therefore there was a duty of disclosure. Not right. First, there has to be a duty of disclosure or an affirmative statement, in which case we're under the misstatement plan, right? But there's got to be an affirmative duty of disclosure, and then the violation of that duty of disclosure has to be material. Here, the materiality test is satisfied. You can put a check on that. The question is there a duty to tell the market about changes in the underlying sales projections? Is this clear? Nod your heads if this is clear. Raise your hand if you have a question. Yes, Andrew. Right. So the outcome in Burlington, this is the Supreme Court, right? So formally speaking, Burlington is, let's say, a more authoritative statement of the law. But the outcome, the analytical framework, sort of the steps you go down are given to you here in Burlington. And at the end of the day, what it's going to come down to is there that duty or not? Because if you find that there's a duty to correct, as opposed to no duty to update, which is kind of how this stuff cashes out, basically, materiality is going to be satisfied and the other elements of liability are going to be satisfied. There's going to be reliance and causation. Okay. So the question is, what is the scope of the duty to correct? That's really the question. It all comes down to how much must be corrected. And notice again that just leads you down the path of it seeming so obvious what in fact falls in the duty to correct, like the blurry facts. This is a judicial technique. You should now have this developed. If you didn't develop it in other classes, you should develop it here, which is like, they pick an anecdote that's so extreme that, of course, it's obvious that there's a duty to correct. The real challenge is, like, where do you draw the line? Sales figures, there are assumptions that go into these models. Like, what if the assumption is, we're going to have 100 people a day visiting our store, and it turns out we have 50 people a day? Now, this is like a perfect exam question, right? Like X company built this model, and the model spit out the earnings per share projection or the sales figure, projection. And we have 20 million in sales, and what went into 20 million in sales? Well, some complicated black box-ish algorithm where we can identify some inputs. And the question is, are those inputs like the blurry facts? Like FAX, the blurry, right? You're supposed to be guided by this certain set of narrow forward-looking statements text. That is, you're supposed to be guided by this example of errors in italics of the type we have identified. That's supposed to guide you. That's the doctrine, formally speaking. But then the court finds, actually, that in the case of Burlington, as Anders pointed out, there's no duty to correct. Yes? Well, formally, doctrinally, the court is going to say the duty to update concerns statements that were reasonable at the time may become misleading when viewed in the context of subsequent events, but do not involve an error of the type that turns you into the duty to correct. Because the duty to correct also involves statements like 10,000 units that we misread as 100 that become misleading in light of subsequent circumstances, right? Because the subsequent circumstances are, oh no, I misread the facts, right? It was blurry. Now I see that 3 weeks later, and I go back and correct it. The only difference between the general formulation of the duty to update and the duty to correct is that the duty to correct is supposed to concern things like the 10,000 getting smudged to 100,000. But what are those? I mean, this is the problem, right? The problem is that formally, doctrinally, there are two different things. In reality, any particular assumption that goes into your model can probably be spun one way or the other. Maybe there are some cases that involve macroeconomic assumptions, right? Maybe the clearest of the sort of Vietnam War type assumptions, like we're not going to have a recession, that's not like the 10,000 getting smudged to 100,000 in the facts. So I'll agree with you, Magdalena, there can be cases that seem to clearly fall outside of a correction. Unless, let's even take that example, unless you read the initial projection as having been based on a particular macroeconomic assumption. You see, this is what lawyers do, right? Like, we reinterpret the world ex post and say, actually, the GDP of the US economy was a really, really, really key fact on which we relied to make this projection. And so, well, you would characterize it that way if you were the plaintiff. This was a fact that went into the projection. And so the moment they realized that, in fact, macroeconomic projections were shifting, they were under a duty to correct that mistake. So it's really hard to separate the duty to update from the duty to correct. Do you agree? Can you think of a test that would resolve these cases one way or the other? Sure. So you can say, well, we'll be very conservative, but that's also a policy choice, right? So the policy choice to say, we'll construe the duty to correct very, very narrowly, allowing you to more or less not update the market, which is the Burlington outcome, is also a policy choice, right? It's a policy choice. It's a choice to let possibly inaccurate, misleading projections go out there on day one, let the clock run and time goes on, and then, in fact, the market is never informed until the next projection. That is a policy choice. It is a choice to view the relevant inputs as not concerning the kinds of errors of a kind of a facts that's smudged. Okay. But that is itself purely a policy judgment by the judiciary. If you've not been totally turned into realists now, you should start to see judges do this. They do this all the time. And the Supreme Court, to its credit, probably because they have better clerks, on 1063 comes clean, right? They say the federal securities laws, this is in the second paragraph, 1063 of your casebook, as they stand today, aim at encouraging companies to disclose their forecasts. Here they go. They acknowledge what they're doing. A judicially created rule that triggers a duty of continuous disclosure of all material information every time, remember, this is not about materiality, that's always a requirement, so keep this stuff clear, of all material information every time a single specific earnings forecast is disclosed would likely result in a drastic reduction in the number of projections, such projections made by companies. It is these specific earnings projections that are the most useful to investors in deciding whether to invest in a firm's securities. The only types of projections that would be exempt from the duty of continuous disclosure advocated by plaintiffs, and hence the only types of projections that would likely be disclosed under the rule proposed by plaintiffs, would be vague expressions of hope and optimism that are of little use to investors. Therefore, I'm just skipping a little bit, adopting the plaintiff's disclosure theory would severely undermine the goal of encouraging the maximal disclosure of information useful to investors. And in case you were wondering where that goal came from, it's going to cite to a judicial decision. I mean, when did we say that the securities laws have the goal of encouraging the maximal disclosure of information? Well, useful to investors, okay, which is basically probably all information. Is it? Maybe, maybe not. I mean, one way to read this is that this reflects our framework, this statement. Kind of, we can charitably interpret it as reflecting the information content of disclosure concern that we articulated in the materiality conversation, which is that not all disclosure does reduce uncertainty about what a firm is worth. So you could read that qualifier, not useful to investors, as the court, you could charitably construct it as the court sort of attuned to our concern. But that's not what the court is doing, right? The court isn't saying, look, we've decided that the lack of ongoing disclosure strikes the right balance between disclosure and between information and informed trading. We don't even see the court saying, you know, we think that in this case, the initial projections are likely to be more sort of uncertainty reducing than a world where you have ongoing. No, they make an assumption. They cut to one sort of worst case, which is that if companies were subjected to ongoing duties of disclosure, they wouldn't say anything from the outset. That's the court's reasoning. Just so you understand, so there's no confusion, this is all economic theory and policy analysis. Like, in case you were wondering why any of the stuff we were talking about before is useful, it's because you have paragraphs like these, which are supposed to reflect a kind of reasoned, consideration of what's going to happen to the market if we construe the duty to update in one way or another. But I don't know about you, but it seems to fall short in many ways. I mean, first of all, the securities law is full of ongoing continuous disclosure, and many times we assume that will have no effect on whether companies are going to provide information at the outset. Like most of the S1 items concern facts that are then subject to ongoing periodic disclosure. There's an assumption here that forward-looking statements and projections are the kind of thing that if, in fact, firms had to then update frequently, they would resist making from the outset. That's a very strong, problematic assumption, right? I mean, if anything, there's an investor protection rationale for making sure that investors have updated information. And the incentives for firms to disclose at the outset wouldn't, to me, be harmed. I mean, maybe you think differently. But I can't really see why a company would be worried about why a firm wouldn't want to disclose an initial earnings forecast, because it has to disclose updates. Because after all this rule would do is require updates to be pushed out to the market. Just like Form 8K requires material definitive agreements to be pushed out to the market. A whole host of categories. So there's something really incomplete about this paragraph, and it shows you why when the court tries to sort of do a little bit of economic analysis, like, there isn't a lot of thought here. There isn't a lot of depth. It's sort of a knee-jerk assumption, right, that if we require ongoing updates to earnings forecasts as you get more information, that would somehow chill disclosure from the outset, which is, it could. It might have no effect. We have no evidence one way or the other. We don't even have a theoretical argument on the court's part. What it definitely will do is what? You should now have an instinctive reaction to this kind of thing. putting it back always in the framework of the class. Disclosure versus informed trading. Less disclosure means more informed trading. This should be automatic, and it should come out on the exam, and it should come out, right? Like, if you allow companies to remain silent, like Burlington, about new information, that benefits informed traders. Like, there will be hedge funds out there who will buy or sell in situations like these. There are, for sure. They exist. So if you have a hedge fund, you want to go get information like Burlington's, like you have an incentive now, right? You have an incentive to sit outside Burlington Coat Factory and count how many people come in. And as you see fewer and fewer, you start to think, oh, maybe I'll short. The company knows that the sales figures are going down, but the company doesn't have to tell the market because the Supreme Court has decided that doing so would be socially bad on average. That is, it would chill disclosure in the first instance. So what do you do if you're a hedge fund? You sell, right? You sell. Because at some point, Burlington's going to have to tell the world that it had crappy sales. And when it does that, the stock price is going to tank, and you profit. It's all disclosure versus informed trading. Nod your heads if you see this, okay? Like, it should start to come natural. Like, this is just a policy choice. It's just a choice to favor informed trading in this setting. That's it. Without really an argument as to why that's a good idea. As to why, in fact, other than this chilling concern, which is always the case, it doesn't seem to have much basis in this setting, other than by pointing out that, we have some goal of encouraging maximal disclosure of information, which, by the way, if that's the goal, would an ongoing disclosure further it? Like, okay. At least they came clean. Yes?
To an extent, the ongoing disclosure could create the same issue that they discuss in the dissent of Texas Gulf, where there's information that's causing assumptions by investors because they don't necessarily they're making incorrect assumptions based on information being put out on blast all the time. Like,
sure.
That this company can't do correct projections, or that they didn't, evaluate all the correct whatever it is.
Yeah, so let's an exercise for thinking of preparing for the final, which is a long ways away, but we might do a little midterm question. I just want to make sure this doesn't seem too far removed. So, Ben's argument, look, it could be that, in fact, this is confusing information. So this is like the food poisoning, right? This is I'veGotPoison.com, and we don't want I'veGotPoison.com to be sort of out there. Why? Because people make incorrect assumptions, or we don't want the law at least mandating it. Well, so great, but think about earnings projections. I mean, there isn't a right or wrong answer. That's the kind of thing you want to say, right? You want to be thinking about that argument. But you might push back and say, look, I mean, earnings projections out of all kinds of information are very, very concrete. Now, it could be that the later projections are systematically worse than the earlier projections, but I find that hard to accept. If anything, projections should get more certain with time. Maybe. I mean, so you could construe a story whereby the interim updates end up inducing greater volatility in what we think about the firm, greater uncertainty. Not because any particular update has less information, but because updates by nature are volatile. And so maybe this is a preference for less volatility. So but then you have to ask, are those initial projections, if they're wildly inaccurate, they might be causing more overpayment and underpayment. Even if later on you'd be issuing a lot of volatile updates, maybe that would in fact reduce overpayment and underpayment. So it depends on the interplay, right, between the information content of each disclosure, that is how misleading or not it is, versus whether or not just sort of inducing volatility, like changing people's minds a lot, is actually a good thing. And here, the court seems to really worry that changing minds a lot is going to have this sort of terrible effect on the market. Notice that happens like all the time. In fact, changing people's minds is one way that we get a convergence of opinion, right? So if we disagree a lot, generally that often, like we might ultimately disagree in the end, but disagreement is one way we often come to a resolution because it's precisely the fact that we're changing our views that can lead to more certainty about what the firm is worth. Because different participants in the market will say, oh, look, I knew there was something about those coats that wasn't selling, and, oh, but actually maybe it's not as bad, and that can lead to a convergence. These are the kinds of questions, though, that matter. And the point is, the court doesn't really seem to engage in this analysis at all. It just jumps to a conclusion, like it knows the outcome. It cares about the question. That's the motivation behind the decision. But it doesn't really rigorously examine it. You want to theoretically examine it like we just did, that is teasing out the different implications of what could happen. But I also want to remind you of the tension we discussed earlier on, which is that there is this tension between advocacy and science, right? So one way to think about a question like this, like forward-looking statements, is through the lens of scientific research. That is, you could say whether or not ongoing disclosures will chill ex-ante information or lead to uncertainty on the part of shareholders is all empirically testable. In fact, the SEC took this approach with the tick size pilot, if you're familiar with that, where, this is a side trail, but they basically did a randomized experiment where they let some companies trade in nickel increments and others trade in pennies. Now that's one, it has some issues, but that's one evidence-based approach to thinking of a question like this, right? You could say what we'll do is we'll randomly let some companies reduce their ongoing disclosure, or will require some companies to provide ongoing earnings projections. That would at least give us some data about whether or not the effects that the court assumes and cites some judicial decision rather than empirical data would in fact lead to that outcome. I mean, this is a great example of the preference for advocacy in the practice of law over science, right? You're going to make a statement like adopting the plaintiff's disclosure theory would severely undermine the goal of encouraging the maximal disclosure of information. Even if I embrace the goal, the authority for that proposition is another judicial opinion, right? That is a sort of anti-science bias in the judiciary and in the practice of law, I would go so far as to say. Because if you were a scientist about it, you would expect an empirical claim like that to be backed up with empirical evidence. And when the judiciary de facto goes in a policy-making enterprise, okay, it often does so without empirical data. And so you want to be attuned to the implicit, empirical claim you're making, which is that, in fact, this would be the outcome if the law were as the plaintiffs were suggesting. Okay? Does everyone see that? So this is the outer edges of the course material. But, if you're thinking sort of what is a really great exam answer, it'll touch on some of these outer edges too, right? Which is to really think about how we're approaching this question and what tools we're using to get there. Does that make sense to everyone? Are there any questions on this before we leave Burlington? Davia. The distinction between the duty to update and the duty to correct, by law, the Supreme Court has said that the duty to correct involves errors of the type it's page 1061 of the opinion, right? Errors of the type we have identified. That's the test, right? Now the question, what falls into that? What is an error of the type we have identified is the problem. But the duty to update is basically any information that's not encompassed by the duty to correct that arose after the fact, right? Well, what is the scope of the duty to correct? The scope of the duty to correct is the kinds of circumstances that they are going to illustrate with an example of a blurry fax where 10,000 gets smudged to 100,000. Okay? And those are the types of errors that the Supreme Court says are covered by the duty to correct. In other words, your intuition is right. Nobody knows. Like, at most, if you did smudge a fax, you kind of have, some guidance here, right? And one more institutional comment. Like, Davia's point is a great one, which is that, like, even articulating the legal test is really hard. It's really hard because there's no law here, almost. It's very, very law-light. Now, you might also institutionally object to the Supreme Court being the actor here. So I remember I mentioned that in the 33 Act setting in general, we have disclosures reviewed by the Division of Corporation Finance. Now the question is, are they perhaps institutionally, as an actor, better suited to draw these distinctions? So it's not only about theory, about whether or not we want, as a matter of trading off disclosure and informed trading, we want a particular disclosure rule. It's also about who should be responsible for deciding that. These are all questions that you want to be thinking about and that you want to be addressing, right? So you might not even take issue with the rule. You might take issue with the Supreme Court being the institutional actor who's laying this down, because by necessity, as Davia points out, they have to set a rule that's very general, because that's what judges do. They're not available to evaluate the next disclosure and tell you whether or not it is, in fact, the kind of fact that should be disclosed under the duty to correct. They can't evaluate the next case until it comes up before them. So we can have other judges do it, but that means litigation. So keep in mind this sort of institutional competency question. Always a relevant question. Who should be deciding? Do we want plaintiffs and defendants and judges? And remember, most litigation is resolved via settlement. So actually, these determinations in this setting would mostly be sort of off the books. They would be resolved in settlements, which may or may not be confidential. Or do we want some kind of review process whereby the SEC makes this judgment? Maybe they, with the help of economists and data, will actually reach conclusions about whether or not, that are scientifically grounded, about whether or not a particular disclosure would have this chilling effect. Okay. All of this, in my mind, is proper course material for SecReg. Even though maybe you've heard it taught in other ways, which is like just the law is what it is, it's never that way, right? You can see that in Burlington. There is no law here. It's very, very, light. So you want to be thinking about these questions. Policy goals, institutional competency. What should we be deciding and who should be deciding it? You didn't hear that. All right. Other questions? Yes, Magdalena. Excellent. Yes. 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 Great. So Magdalena says, look, there's also hindsight bias, so we're more likely to litigate the cases that are wrong, which is another problem. Agree completely. Just keep in mind that the safe harbor has its own effects. The effect of the safe harbor is you get to shut up as a firm, not say anything. That can have downstream implications, right? So basically, this is all back to disclosure versus informed trading. The safe harbor in this setting boosts informed trading, right? Now that's a policy choice. Maybe you think that's perfectly fine, but that should be what the court is saying in a way, right? Which is like, in preferring a safe harbor, we recognize, because we don't, but look, the hindsight bias objection is specific to litigation. You could have ex-ante review by the Division of Corporation Finance. You could have an email, just a quick email to an SEC staffer. Hey, our sales figures are not looking so good. Should we have to tell the market this? That wouldn't have hindsight bias. That would be an ex-ante review. So, you could imagine, again, a question where I want to see if you can think that way. I want to see if you can think about issues like these, but then also creatively engage with institutional competency. Yes? Remind me your name? Amy. Yes. Did I skip that? I'm sorry. I saw Alito, and that was my mistake. Third Circuit. Thank you.
Standards like the circuits across the board that have just kind of adopted this standard, or is this just the Third Circuit?
No, Burlington is law. But the issue I mean, the problem you have here with Burlington is, thank you for that. The problem you have with Burlington is that the duty to update and the duty to correct are fundamentally ambiguous. Now, you have the same problem with Time Warner, right? So you actually had a different outcome, but it is ultimately the same analysis. Thank you. Yes? Well, the casebook does point that out in a comment. But remember that even though there is, so you want to think of the duty to correct and the duty to update as just ex post choices by the judiciary. It doesn't matter. A court can, look, you can have a circuit say, we don't think that there's any duty to disclose future information to investors. But then that just moves the ball towards whether or not the initial disclosure was misleading in some way. And anti-fraud, there can still be a question of anti-fraud liability. So you're absolutely right to say, look, courts are going to come down one way or the other, but I want you to see that this is just a policy choice. This is a policy choice at the end of the day. It is a choice as to whether you're going to prefer disclosure to informed trading. That's it. And you're going to use the doctrine to achieve that goal one way or the other. That's it. Each circuit is going to come down slightly different in the language it uses and whether or not it forecloses a formal doctrine. At the end of the day, those are choices. Those are policy choices. Policy choices. Other questions? Okay. So now let's look at Section 11. In case any part of the registration statement, I'm reading from the screen, when such part became effective, contained an untrue statement of a material fact, or omitted to state a material fact required to be stated therein, or necessary to make the statements therein not misleading, any person acquiring such security may sue every person who signed the registration statement. That's 11.1. Every person who is a director of or partner in the issuer at the time of the filing of the part of the registration statement with respect to which his liability is asserted. Every person who, with his consent, is named in the registration statement as being or about to become a director. And very interestingly, every accountant, engineer, appraiser, or any person whose profession gives authority to a statement made by him who has, with his consent, been named as having prepared or certified any part of the registration statement, or as having prepared or certified any report or valuation which is used in connection with the registration statement. And 5, every underwriter with respect to such security. Now, Section 11 liability is very broad. And unlike 10b-5, it concerns the predicate duties to be swept in under Section 11 are much clearer. And that is to say, Section 11, because it attaches to the registration statement itself, you generally are not as concerned with whether there is or isn't a duty to disclose. Rather, you're trying to figure out whether or not, if there is an affirmative misstatement, one of the exceptions or one of the safe harbors that could otherwise apply would be relevant to your situation or not. And here, so the contours of Section 11 liability are really not about the policy choice between what we disclose or who should make that judgment, but rather about which actors are held accountable for misleading facts or omissions. Take the case of accountants or auditors, as you read in the WorldCom case, or Barcris. The scope of Section 11 liability can be very broad. In a way, what Section 11 is trying to do is to strike a balance between holding every entity liable, every possible entity who could be liable for a misstatement, and holding only those who have direct responsibility over the material. Now, if you take the case of the accountants, it's very easy to see the argument that most people in the company trust the accountants to prepare the registration statement in a particular way. That is, they're not able to look beyond the application of generally accepted accounting principles and see what it is that the accountants are relying on. They may be aware or not of certain facts that gave rise to the accounting statements, but at the end of the day, the financial statements are prepared by professionals. And so there's some sense, and this is the logic that underlies Section 11, that if you're relying on an expert, you are entitled to kind of rely on that expert. That we don't want liability to penetrate all the way through to every member of the firm who is relying on an expert. And you might think, look, one reason for that is that these experts are, at the end of the day, they have strong reputational incentives. And so we think that if Section 11, or liability for misstatements, should do anything, it should apply to those who lack other external constraints and incentives like reputation. So if you go back to our framework of overpaying and underpaying, if your concern is, look, a company's going to withhold information because they know something that the rest of the market doesn't, and that's going to lead to an misvaluation of what the firm is worth, you might think that that is more likely to occur on a firm-specific basis, right? That is, it's not likely to be, at least you hope, that a famous accounting firm, KPMG or you name it, is going to be engaged, is going to be participating, at least knowingly, in the sort of over or underpayment operation. That is, they're not likely to be misleading investors because, after all, their reputation's on the line. As a result, the Section 11 liability regime is premised on the notion that these entities should be held liable for the materials that they prepare, for those parts of the registration statement that they are responsible for. Whereas if you're an issuer, you should be entitled at some level to rely on their expertise. And this idea that as a starting point, there should be some separation, some scope as to who is held liable is what underlies the entire Section 11 disclosure regime, liability regime. Question?
Yeah. So do the lawyers who prepared the entire registration statement fall under Section 4 there? Like, could you see the lawyer?
So you read Barcris, right? You read WorldCom. So you know that the answer is maybe. And we're going to sort of unpack the standards here. But the idea, let's start with just the idea. I want you to understand the idea, okay? Whether or not, the lawyer is a great example, because whether or not the lawyer can be thought of as an expert is in many ways one of the, if you want to think of like a hypothetical that really threads the needle and kind of splits the rationale, it's a good one. Because lawyers are like accountants in that they have strong reputational incentives. They are performing kind of specialized expertise work. But they're not like accountants in that they're supposed to be looking at facts that should be known to the entire firm. And so there's a sense, and you saw this in Barcris, there's a sense that lawyers aren't necessarily exactly like accountants, right? That if we're going to hold them to a standard, we're going to hold them to a standard that's a little bit closer to the firm itself. Now, these are the rationales, right? I'm trying to get you to see the idea behind Section 11 is that Section 11 is really trying to thread the needle as to who exactly should be viewed as someone who a firm can rely on, and what kinds of statements, what kind of parts of the registration statement should we be holding the company and its own executives to personally. Now, one of the first points you should pay attention to in Section 11 is that, in fact, the standard here for liability is one of strict liability. So there's no mens rea, so to speak, for Section 11 liability. It is, in fact, a strict liability provision. Because it's a strict liability provision, it's going to really matter who is in and out. You're not going to get out of Section 11 liability by showing that you reasonably believed differently, or that you didn't have facts in front of you, that you trusted another division. That's not going to help. If you signed the registration statement, if you were a director or a partner in the issuer at the time of the filing of the registration statement, if you're about to be named as a director, you may be sued. Now, there are some exceptions, and it's a good idea to look carefully at these. Notwithstanding the provision of subsection A, no person other than the issuer shall be liable as provided therein, who shall sustain the burden of proof. 1, that before the effective date of the part of the registration statement with respect to which his liability is asserted, he had resigned from or taken such steps or as permitted by law to resign from or cease to refuse in his office. In other words, one of the things you can do to get off the hook of Section 11 is to disclaim responsibility for the registration statement, but that requires you to resign or to cease or refuse to act in every office capacity relationship in which you were described in the registration statement. There's a safe harbor for letting the SEC know, so subsection 2, that you advise the Commission that some part of the registration statement had become effective without your knowledge. All right? So the rationale here is you can tell the market that the company is doing something fishy. That's basically what subsection 2 allows for. Now, subsection 3 is where it gets interesting, and this is going to be the subject of a lot of this litigation. As regards any part of the registration statement not purporting to be made on the authority of an expert, and not purporting to be a copy of or extract from a report or valuation of an expert, and not purporting to be made on the authority of a public official document or statement, he had, after reasonable investigation, reasonable ground to believe, reasonable ground to believe and did believe at the time such part of the registration statement became effective that the statements therein were true and that there was no omission to state a material fact required to be stated therein or necessary to make the requirements not misleading. And B, as regards any part of the registration statement purporting to be made upon his authority as an expert or valuation as an expert, he had, after reasonable investigation, reasonable ground to believe and did believe that the statements were true. And then there's a few other provisions. Okay, this is known as the due diligence defense. What does that let you do? Well, basically, it lets you as an expert say, look, if I am an expert, I did the best I could to figure out what the facts were about this company. And if I am not an expert, as regards subset part A, any part of the registration statement not purporting to be made on the authority of an expert, I had conducted a reasonable investigation. So now who benefits from this provision? The underwriter. So the underwriter wants to say, look, I did the best I could. As regarding the non-expertise portions, the portions of the IPO, of the file, of the registration statement that that were not made on the authority of an expert, I made a reasonable investigation. You can't hold me accountable for more than that. That's what 3A allows you to say, particularly as an underwriter. B, as regard the part of the registration statement purporting to be made on his authority as an expert, I had, in fact, similarly relied on an expert, and the experts can claim that they had engaged in reasonable due diligence as well. In determining what constitutes a reasonable investigation, a reasonable ground for belief, the standard of reasonableness shall be that of a prudent man. And then we get to the damages. So the theory behind Section 11, we'll talk about this, we'll really unpack WorldCom, and particularly, but also BarChris briefly next on Thursday, is that if I'm relying on something that we normatively want to hold issuers and experts to, I'll be off the hook. The theory behind Section 11 isn't you're off the hook for what you didn't know. It's a strict liability standard. The theory is we want to induce a kind of preparation. We want to induce a kind of effort. And when you practice and you see due diligence, where that is arising in response to this standard. It's arising in response to an idea that while we want to hold issuers accountable for misstatements, what we're really trying to do through Section 11 liability is encourage them to scour and search out the facts. And so the expertise to non-expertise distinction, which we'll unpack when we look at the facts of those cases, and we see the court finding that as to a particular point, the lawyer should have known, and as to a particular other point, the accountant, didn't really reasonably investigate because there was a red flag. That this is all about incentives, right? This is about encouraging firms, issuers, and underwriters and experts to do due diligence, to look at the companies and to hold them accountable if they don't conduct a reasonable investigation. So Section 11 is really a procedural framework that's not so much focusing on substantive rules or even the contours of, even though materiality does show up there. It's really about who should be held accountable and what sort of behavior should we induce. Now for next time, we'll go through, BarChris is an incredibly long opinion. It's good to read to see how each category of defendant is evaluated by the court as being more or less sort of should have been in the know or whether the investigation was reasonable or not. For my purposes, I'm not so interested in whether or not a particular set of facts constitutes a reasonable investigation. It's always going to be fact-specific. And so here, we're not going to spend too much time. What I want you to do is to be able to see, look, this is how the court applies the test. The court is looking person by person and asking, what do they know? What was the standard? We'll restate the standard at the beginning of class next on Thursday. We'll go through BarChris and WorldCom, and we'll see, look, each category of defendant here is held to a different standard, and here are the facts that the court is using, but it's hard to infer from that what is going to happen in a subsequent case, right? This is a sort of prophylactic regime where the goal is to encourage you to engage in this sort of due diligence, to be really thorough, and then to hold you account after the fact if there was something that you should have paid attention to but didn't. It's actually 80%, 90% of the practice in this area because it's really all about the facts of each particular case. But it's not something that I think it's worth spending too much time on. So we'll quickly, at the beginning of next class, go through those opinions, what the analysis was as to each category of defendant, and then we'll move on to the other bases for liability very briefly. Again, this week, it's more about you getting a sense for what are the grounds that you could bring a claim under the 33 Act. But it's not the most interesting. I mean, these are technical procedural requirements. I want you to understand what they are. You'll need to understand what they are. But this is really more about sort of eating your vegetables, right? This is checking the boxes so that you can know what the requirements are to bring these claims. Any questions before we wrap up? Okay, so Thursday, no class or office hours tomorrow. Thursday morning, I'll see you again at 10:40. Thank you. Yes.
Send it over. I'm a little more bullish on Snapchat. Actually, students
Yeah, exactly.
I'm not sure even to the point that I understand this.
Yeah, me neither.
I'll see you on Thursday.